Let me tell you about Rachel Osei, 38 years old. Senior surgical nurse at Meridian General Hospital, a mid-sized regional medical center in Georgia serving 340,000 people. Rachel had been at Meridian for 11 years. She had worked in the surgical unit for 8 of those years, assisting in over 3,000 procedures across general surgery, orthopedics, and oncology. She was the kind of nurse that surgeons requested by name. The kind that junior residents quietly watched during complex cases because watching Rachel work was a better education than most formal training. She was also the only person in that operating room who had documented what she witnessed during a procedure involving Dr. Franklin Morse. Dr. Morse was a senior orthopedic surgeon. 57 years old, 22 years at Meridian. Golf partner of the chief of surgery. Godfather to the hospital administrator's youngest child. The kind of physician whose institutional relationships had built a protective layer around him that most complaints never penetrated. Rachel had witnessed a surgical error during a routine knee replacement. The patient, a 64-year-old retired teacher named Margaret Fowler, experienced significant complications afterward. She required a second procedure to correct the initial error, spent 11 additional days in hospital, and suffered permanent reduction in joint mobility. Rachel documented everything she witnessed. Her notes were precise, time-stamped, and consistent with her standard documentation practice. She submitted a formal incident report through the hospital quality assurance system within 24 hours. The quality assurance review took 6 weeks. The outcome was a single-paragraph letter. No corrective action required. Rachel had also, because she understood how institutional protection worked, made personal copies of her incident report, her contemporaneous notes, and the operative record before submitting anything formally. She stored those copies in a secure personal archive. She called an attorney named James Webb, who specialized in healthcare employment and medical whistleblower matters, within a week of submitting her report. Just in case, she told him. James told her that was exactly the right instinct. 14 months later, Margaret Fowler filed a medical malpractice lawsuit against Dr. Morse and Meridian General Hospital. Her attorney identified Rachel through a review of the operative records and reached out through proper legal channels. Rachel spoke with James before responding to anything. James advised her that she had both the legal right and potentially a legal obligation to provide truthful testimony about what she had witnessed. Rachel agreed to be interviewed by Margaret Fowler's legal team. 3 weeks after that interview, Rachel was called into a meeting with Dr. Morse, the chief of surgery, and the HR director. She was informed that her position was being eliminated as part of a departmental restructuring of the surgical nursing unit. No other positions were eliminated. Rachel was the only person affected. She was offered 8 weeks severance and a non-disparagement agreement. She called James from the parking lot before she reached her car. "James," she said, "they just eliminated my position." 3 weeks after, I was interviewed by the plaintiff attorney in a Morse malpractice case. "Did they give cause?" James asked. "Departmental restructuring," Rachel said. "I am the only person affected." "Did you sign anything?" James asked. "Nothing," Rachel said. "Good," James said. "Go home. Do not contact the hospital. Do not sign anything. I will have a letter to their general counsel by end of week." Rachel went home, made herself dinner, opened her secure archive, and confirmed everything was still there. Then she called her sister. "It happened," she said. "Your attorney is already on it," her sister said. Now, if you believe the most important preparation is always the kind you do before you need it, subscribe to Tangled Stories. I am Brett. Around here, the ones who document before anything happens always have the strongest position when something does. James Webb sent his letter to General Counsel Patricia Vance on a Friday morning. 3 pages. It outlined the timeline. The incident report submitted 14 months earlier. The quality assurance outcome. The malpractice lawsuit. Rachel's witness interview. The termination 3 weeks later. It cited the applicable federal and state whistleblower protection statutes covering healthcare employees who report patient safety concerns and cooperate with legal proceedings related to those concerns. It noted that the termination of the sole witness to the operative events at issue in active malpractice litigation, 3 weeks after that witness had been interviewed by plaintiff counsel, created a pattern that would be very difficult to characterize as coincidental. And it included one final paragraph Patricia read 3 times. Ms. Osei retains complete copies of her incident report, her contemporaneous operative notes, and the operative record from the procedure at issue in the Fowler litigation. She intends to provide complete and truthful testimony in that proceeding. The manner in which the hospital responds to this letter will be relevant context for that testimony. Patricia called outside counsel. Outside counsel reviewed the letter, the timeline, and the applicable statutes and called back within 4 hours. The termination timeline is extremely problematic, Osei counsel said. 3 weeks after a witness interview in active malpractice litigation, no other positions eliminated. No prior restructuring documentation. This is a straightforward retaliation pattern. What is the exposure? Patricia asked. Reinstatement, back pay, front pay, compensatory damages, and potentially punitive damages if willful retaliation is established, Osei counsel said. And there is a secondary problem. Osei counsel explained. If the hospital had terminated a material witness in active malpractice litigation in retaliation for cooperating with that litigation, the plaintiff attorney in a Fowler case would almost certainly learn of it. When she did, the termination would become part of the narrative of the malpractice case itself. A hospital that had protected a physician through an inadequate quality assurance review and then terminated the only eyewitness to his error when she cooperated with a lawsuit was not a sympathetic defendant. Patricia called the chief of surgery, then the hospital administrator. By end of day, the administrator had authorized Osei counsel to contact James Webb and explore resolution. James called Rachel that evening. They want to talk, he said. Rachel said she assumed they would. Reinstatement is the floor, not the ceiling, she said. Tell me what you want, James said. Rachel had thought about this since the afternoon in the parking lot, she told him. James delivered her terms the following week. 1. Immediate reinstatement with full back pay and a written guarantee that her employment could not be terminated without documented cause and a formal review process for 5 years. 2. Formal written acknowledgement from the board that her termination had been inconsistent with her rights as a patient safety reporter and a litigation witness. 3. An independent external review of the quality assurance process used to evaluate her original incident report with findings reported to the board. 4. The establishment of an anonymous reporting channel for surgical nursing staff, administered by an independent third party, with mandatory response timelines that could not be overridden by departmental leadership. 5. A settlement reflecting the harm caused by the retaliatory termination, the reputational impact, and the distress of being removed from a position she had held with distinction for 11 years. Osei counsel presented the terms to the administrator and gave an honest assessment of the alternative. The whistleblower retaliation case is strong, Osei counsel said. The Fowler malpractice case has a material witness who is now also a retaliation victim. The two cases together create a narrative about this institution that would be significantly more damaging than the cost of resolving both matters now. The administrator authorized negotiation. The negotiation took 2 weeks. The settlement was reached on a Thursday. The number reflected the harm, the timeline, and the institutional failure. Rachel's reinstatement was confirmed in writing with the 5-year employment protection. The board acknowledgement was 3 paragraphs, factual, signed by the board chair. The independent quality assurance review was commissioned within 30 days. The anonymous reporting channel was operational within 90 days. Rachel returned to the surgical unit on a Monday morning. She did not make an announcement, did not send an email. She scrubbed in for her first case at 7.45. The surgeon she was assisting, Dr. Priya Nair, looked at her across the operating table as the procedure began. Good to have you back, Dr. Nair said. Good to be back, Rachel said. And they went to work. The independent quality assurance review, completed 4 months after Rachel's return, found that the original review of her incident report had been conducted without independent clinical input, had not followed the hospital's own documented protocols, and had been completed in a timeframe inconsistent with the complexity of the concerns raised. The board adopted every recommended protocol change. Dr. Franklin Morse retired from Meridian General 6 months after Rachel's return. His retirement was announced as planned and voluntary. The Fowler malpractice litigation settled confidentially. Rachel provided her testimony honestly and completely. The chief of surgery accepted a voluntary reduction in administrative responsibilities. The HR director who had conducted the termination meeting left Meridian General 8 months after Rachel's reinstatement. Patricia Vance implemented a mandatory legal review requirement for any termination involving an employee who had filed a patient safety report or been identified as a witness in active litigation within the preceding 24 months. She called it, internally, the Osei protocol. James Webb presented the case without names at a healthcare employment law conference the following year. The most straightforward retaliation pattern I have seen in 14 years of practice, he said. Incident report. Witness interview. Termination. 3 weeks between steps 2 and 3. No other positions eliminated. No prior restructuring documentation. If you are a hospital administrator and someone brings you a termination proposal fitting that description, the answer is no. The room was quiet. Rachel was not in the audience. She was in the surgical unit at Meridian General, scrubbing in for the morning case, doing the job she had done for 11 years. She kept one document in a folder on her home computer, not the settlement agreement, not the reinstatement letter, the original incident report, the one she had submitted 14 months before any of this happened, the one she had filed because a patient had been harmed and it was the right thing to do. Underneath it, in a note she had written to herself the evening after submitting it, "Whatever happens next, I reported what I saw. That is the job. That will always be enough." And that, my friends, is how one surgical nurse turned a retaliatory termination into a patient safety reform, a board-level acknowledgement, and the full vindication of the one person who has simply done what the job required. Because some institutions protect their reputations instead of their patients. And some nurses document everything before anyone tells them to. Rachel documented 14 months before they thought to fire her. They found out on a Friday morning when James Webb's letter arrived at 9:14. If this story moved you, subscribe to Tangled Stories, drop a like, and share this with every healthcare professional who has ever been told that reporting a concern is more trouble than it is worth. Because here, every story has a twist. And sometimes that twist is in a secure personal archive that a nurse created 14 months before anyone thought she would need it. I am Brett, and I will see you in the next one.